Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court. It is my great pleasure to be sitting this morning with Justices Singh and Hand, and my name is Gabrielle Wolohojian. So before we get started, I'd like to just repeat a couple of ground rules for everyone. You can stay there or sit down, whichever you prefer. Each side, we have a list of 3 cases today. There'll be no morning break. Each side receives 15 minutes to argue, and the appellate courts in Massachusetts do not permit rebuttal, so don't reserve time for rebuttal. You can assume that we have read your briefs, and if not all, the majority of your appendices. And so you can start your argument wherever you'd like. You don't need to spend your time telling us what the case is about. We know that already. So with that, I'm going to call the first case. Finding my eyeglasses. But I think it's, I hope I have the number right, 2022 P0062, Commonwealth versus Brandon CARRION. And Attorney Colangelo?
Correct.
That was smaller print. Sorry about that. We're ready whenever you are.
May it please the court, my name is Tristan Colangelo on behalf of the defendant appellant, Brandon CARRION. In the brief, there were 2 issues raised: whether the due process requires clear and convincing evidence that the defendant violated the terms of probation by committing a subsequent crime, and whether the trial court's finding that Mr. CARRION violated the terms of probation where it failed to issue written findings of fact or rule on the reliability of hearsay evidence. As to the first issue, as to whether due process requires a clear and convincing evidence standard, at the time the brief was filed a little over a year ago, there was, I thought, an opening to present the argument to the court that recent SJC precedent had perhaps allowed such a review. In the past year, a number of decisions have come down that seem to affirm the preponderance of the evidence standard, and unless the court has any questions on that, I think that's probably an argument better raised in an application for further appellate review directly to the SJC.
Right, so you raised the argument in your brief, and we'll just consider it on that basis. You don't need to spend time at argument.
Thank you, Your Honor. Regarding the second issue, whether the district court failed to issue written findings of fact or determinations of reliability of the hearsay testimony, the issue of written findings of fact is reviewed under harmless error because it does deal with raise issues of due process. And Rule 8 in controlling precedent is pretty clear that written finding facts are required. They're necessary. While the judge did check off the box indicating that he found Mr. CARRION a violation of his probation based on the testimonial and evidentiary evidence presented at the hearing, the space where the judge would then cite which evidence or present findings of fact upon which the basis of that determination was made was left blank.
Go right ahead. Go ahead. May I ask you a question? Are you arguing that the judge did not make sufficient subsidiary factual findings regarding the reliability of the hearsay? Or are you arguing that the judge did not, or maybe you're arguing both, that the judge did not make findings of fact regarding what happened?
It is both. I realized that when I was reviewing my brief, it seemed like the 2 issues blended together a little bit, but the argument is both, that there aren't sufficient findings.
I mean, with respect to the first one, I'm looking at RA 7, which is the probation violation finding and disposition. The judge did check off all the bases upon which the judge was relying for determining that the hearsay was reliable, and then added in that it was for Worcester police officers, correct? Why isn't that enough in terms of the findings for the reliability of the admission of the hearsay?
Yeah, it seems like the judge here just did a wholesale adoption of everything, right? Everything presented was through these 4 officers. That's who's listed.
Yeah, the judge could do that.
Well, what it does, what it deprives the defendant of is the ability to look at which specific hearsay statements presented through which witnesses. This case was a little confusing because you had 4 different police officers, but they presented hearsay evidence of more than 4 other witnesses. So we don't have a good record of which witness testimony the judge is relying on to find that he was in violation of his probation.
Okay, but that seems to me, again, going to the second piece, which is, are you contending that the problem is that he didn't make sufficient findings about what occurred, as opposed to the findings necessary to admit the hearsay? Right? So the judge has to make threshold determination to determine whether hearsay is reliable in order to rely on it.
Right.
Are you arguing he didn't make those findings? Because that seems to me a hard argument to make, given that he completed the section on the form.
Yeah, no, I think I understand where Your Honor is coming from on that one, and the issue that jumps to mind is that there is some internal inconsistency in regards to whether the judge could rely on all of the testimony, and maybe that goes to your point. That's really a second issue problem, but for instance, whether the judge credited the victim's testimony that he didn't know who assaulted him. It seems to be that if the judge is crediting, considering that as reliable and relying on that, that would not support finding that Mr. CARRION was in violation of his probation by committing the crime.
Right, so that seems to me not that the officers were not reliable, because you're in fact, that argument you just made seems to presuppose that the officer was reliable in reporting what the victim had said.
I'm making the assumption based on what the judge found, but wrote down that he found that the 4 officers were credible. It's just, you can't go beyond that and say, when one officer testified to what the victim said, as well as 2 or 3 other witnesses, to identify what testimony is the judge relying upon. I think the standard is that he needs to make a determination that this is hearsay within hearsay. So the witness that the officer heard it from, that testimony was reliable. Not necessarily that the officer presenting it was reliable when they were in the courtroom that day, but that the officer at the time they took the testimony from that recipient witness, that recipient witness's
Why?
testimony
That's not
was
the
reliable.
recipient witness's testimony is not hearsay.
No, because it was presented through the officer. The recipient witness never testified in court. There was no ability to cross-examine. It was just the officer presenting it. So I believe that.
So is what you're asking for, why wouldn't the relief be that it's remanded for fact findings?
I think that for this issue, I think that would be appropriate for reliability issues.
What do you identify as this issue?
The reliability issue. And it might be appropriate for the lack of findings of fact as well. The problem is going to be that this occurred nearly 2 years.
I'm really struggling with your argument about that the judge did not make findings regarding the reliability of the hearsay. There's a section of this form where the judge made those findings. What are we to do with that section of the form? Ignore it?
No, I think the way I understood it was that the reliability determination was whether the recipient witness providing the testimony to the officer, whether that was reliable or not whether the officer who testified in court that day was reliable themselves. I don't see anywhere in the record, whether it be the transcript or in this form, where there's a determination that the recipient witnesses provision of their observations to the
Well,
officers was reliable.
it says that the finding is based on hearsay evidence, and in making this finding, the court relies on hearsay evidence and finds that such evidence is substantially reliable, and then gives 6 reasons why.
Yep, I was.
Why isn't that enough?
The argument would be that it doesn't identify which witnesses,
But then he says 4 police officers.
which recipient witnesses provided that testimony to the officers.
Is the recipient witness testimony inconsistent?
Well, I believe it is if you consider the victim's statement himself, that he was unable to identify who
Okay,
committed.
but how is that inconsistent with the other witnesses who testified to other circumstantial or direct evidence of what they observed?
The only way to find Mr. CARRION in violation of his probation for this reason would be a number of different inferences all taken together that he was the only one that was in the area and that committed the crime.
Okay, but
It just doesn't seem likely that that the victim would be unable to identify Mr. CARRION.
well, there had been discussion that both parties involved had been drinking. Is that correct?
There was
And that,
testimony about that.
Some time had elapsed. It wasn't necessarily clear what had gone on in the elapsed time, and the victim had been stabbed by someone, right? So,
That's undisputed, that's right.
so if you were going to assume that it wasn't inconsistent, that he didn't remember who had stabbed him, was not inconsistent with the other recipient witnesses' testimony, then why wouldn't the statement that all of the information provided by the Worcester Police Department officers was reliable take into account also the testimony of or their accounts of what happened from the recipient witnesses? Why doesn't that cover all the bases, I guess?
Yeah, my understanding of the rule is it just requires a little more specificity as to what the reliability determination of that testimony is. Obviously, the argument is that this form wasn't sufficient, but to the extent that the court's not.
Counsel, isn't it, I mean, we have the record, we can take a look at it, we have the record, we have the findings, we can see if the judge's determinations are supported. Isn't it your job on appeal to present to us what is, the problematic piece of it? You're challenging, I assume you're challenging the findings to say that there's some critical piece that the judge should not have credited because it lacks sufficient indicia of reliability. So what piece of the hearsay that came in was critical that lacked sufficient indicia of reliability, and why?
I should have mentioned at the beginning that the judge did make an error when he initially said that all hearsay was admissible, and that the argument would be, you can argue the weight of it, but that it's all coming in. So it's sort of a combination of the fact that the judge first said that all hearsay is admitted, and then we get to this form and it doesn't provide the specificity as to which witness he actually made that reliability determination.
So what shouldn't have come in, on your view, that the judge was wrong in stating that orally, that all hearsay comes in? What hearsay should not have come in?
Well, this is, I think, goes to the problem. That's why the due process clause is implicated, because it makes a job on appeal extremely difficult to know what the judge relied on, what he did not rely on.
But he relied on everything. So
the assumption is that if you relied on everything, what would the problem be?
What should he not have relied on?
Yeah. I don't have that. I don't have a great answer for that.
Do you think that, the standard of prejudice that you articulated in your brief was harmless error, right? So I think this is related to Justice Singh's question. What's the harm? What's the appreciable harm here from the lack of findings if there's no contradictory evidence? In other words, the evidence is not in conflict. Because the only thing you've identified is the victim saying, I couldn't tell who stabbed me, and everyone else could, so that's not really a conflict. So can you please tell us what the prejudice is?
Yeah, there might be a slight difference between the standard for the reliability determination and the failure to put for written findings. Just to flag that for the court, I believe the harmless error standard applies to the failure to have written findings under Rule 8 and precedent, and that the concept there is that it just does deprive the appellant of an ability to review the record and make a meaningful review as to whether the finding of violation is actually supported by the factual
I know, so,
findings.
but here, I mean, there was sufficient evidence. So, so I'm struggling to find out how you would satisfy that standard
Well,
with respect to the absence of the factual findings.
I guess that's where I land, is that there's the absence of factual findings does not allow a meaningful review here. And when you look at both the probation violation finding and disposition form, that leaves that section blank as to the factual findings. And then if you review the transcript, particularly pages 47 and 49, which the Commonwealth point to, it's completely devoid of any findings of fact at all, other than the simple finding that he was in violation of his probation. There's nothing. So it's difficult on appeal to say the judge's decision was supported by sufficient facts without knowing what those facts were.
Well, we know that, right? If a violation was found, the basis for the violation was this criminal act, this criminal conduct. So he found that the facts were sufficient to make out that charge, right? You work your way backwards. And then, so you look at the record, we look at the record, you say, was there sufficient evidence in the record for that? There was. So, your argument needs to be that some evidence should not have come in. And we don't know what, but it sounds like you're having a hard time identifying some hearsay evidence that came in that shouldn't have come in.
Yes, Your Honor, I realize my time is up, but
You may answer.
I guess I'll have to rest on my brief to the extent that it identifies the failure of the written findings of fact to support the ultimate finding of a violation of probation. Thank you, Your Honors.
Well, let me see if there are any further questions. No. All right, thank you. We have your arguments. Attorney Borges?
Good morning. May it please the court. Danielle Borges on behalf of the Commonwealth. The Commonwealth respectfully asks this court to affirm the hearing judge's order revoking the defendant's probation. Moving past the burden of proof argument, as we decided not to discuss that.
Could you please speak up a little?
Sure. I said moving past the burden of proof argument, since we decided not to discuss that, and just quickly discussing the...
We haven't decided not to discuss that, so if you would like to present argument on that, you're absolutely free to.
Okay, briefly, the Commonwealth will just argue that the law is clear that the burden of proof in a probation violation hearing is proof by preponderance of the evidence. The defendant's argument that the court should apply a clear and convincing evidence standard is one that's been raised and rejected numerous times. If there are no questions on that, I'd move to the next argument. Regarding the judge's findings, in open court, the hearing judge in front of the defendant reviewed the evidence and stated his findings for revoking probation. The defendant therefore had actual knowledge of the evidence that was relied on in terms of revoking that probation, and he subsequently obtained a written copy in the form of a transcript, which does satisfy his due process rights. And regarding the hearsay evidence, as discussed in the probation violation finding and disposition form, the judge outlined his justifications for his findings. He noted 6 different reasons why the hearsay evidence was reliable.
What do you say are the oral findings?
I would point to page 47 of the transcript, where the judge states, under the evidentiary standard that I am required to consider in a violation of probation, he's found in violation.
That's not a factual finding.
It's definitely, it could have been more elaborated on the transcript, but I would then point to the probation violation finding and disposition form, where he specifically checks off that he found the defendant in violation of probation based on a hearing and the preponderance of the credible evidence.
Right, and then he doesn't fill in the blank there. So he says, my finding is based on a hearing and the preponderance of the credible evidence, specifically the following testimonial or documentary evidence, which he doesn't complete that portion of the form.
The
So
Commonwealth.
how are we supposed to, we can't supplant that answer, right? We can't supply it. So how do you think we deal with that?
The Commonwealth would argue that this court in the Commonwealth v. Bain case found that a judge's findings complied with due process where the judge left that line blank. So even while it would have been helpful to have that line filled out, it's not necessary, and none of the defendant's due process rights were violated by leaving that line blank. And, yeah. Are there any further questions regarding the hearsay evidence or?
Did you cite Bain in your brief?
I believe I did, but if not, the site is 93 Mass Appeals Court, 724, 2018.
Bain with a B?
Yes, B-A-I-N.
Okay, I may be misreading, but I don't see that in your table of authorities.
Okay.
Bain was a slightly different factual situation, though, wasn't it? Wasn't there more in Bain than there is here?
I think the court was weighing the transcript of the hearing and with the probation violation finding form that the judge filled out. I think that here with the form, it satisfies the defendant's due process rights. I would also, for persuasive authority, point to Commonwealth v. Roman, which was 102 Mass Appeals Court 1118, which was unpublished April of 2023. The Commonwealth did not cite that in their brief, but in preparing for oral argument, I found the case that stated that the defendant's due process rights were not violated, even where the judge didn't mark anything on the probation violation form. It still found that his due process rights weren't violated.
Do we know maybe the judge made oral findings on the record in that case?
I'd have to go back and search. I'm unsure if they were. And again, yes, I think that the judge could have made more elaborate oral findings, but ultimately the defendant's due process rights weren't violated. Are there any further questions? Then based upon the foregoing, the Commonwealth would ask that this court affirm the hearing judge's order revoking the defendant's probation, and the Commonwealth would rest on its brief.
Let me see if there are any questions. No, thank you.
Thank you.
Thank you. We have your arguments. Thank you both, and the case is submitted. Our next case is 2022 P0596, AC versus WJ. I'm going to remind everyone that the case is partially impounded, which means that we should avoid using the parties' names and any other identifying information. All right, so Attorney Miller, you're appearing for WJ.
Yes, Your Honor. Good morning, Your Honors. May it please the Court. Thomas Miller for the defendant appellant. The harassment prevention order in this case must be vacated because the fundamental requirement of the statute that the plaintiff identify 3 acts of harassment was not met here. In order to find 3 acts, the judge must have relied either on the defendant's public online speech that's protected by the First Amendment and by the Massachusetts Declaration of Rights, or on the actions of third parties that the defendant neither intended nor caused and that can't be in any way attributed to her. Neither of those things qualify as harassment under the statute. Allowing this harassment prevention order to stand could have a serious chilling effect on online speech. The internet is the center of speech in our society. Reviews of businesses and products and accounts of personal experiences are ubiquitous. We probably all read them, rely on them, possibly create them ourselves, and the First Amendment protects that. Restraining orders should not be used to retaliate and silence that kind of speech online. I do want to represent to the court that this restraining order is no longer in force. It expired early last month. And otherwise, I welcome the court's questions.
Does it matter that it's expired?
It does, Your Honor, in the sense that if this court finds that it can't affirm the order on the factual findings made by the judge, which I think are quite incomplete and hard to understand in this case. This court cannot remand it, it must vacate. That's the situation in, for instance, O'Brien v. Borowski, that the SJC decided they couldn't affirm, and because the order had expired, they vacated.
Could you go over, you just mentioned, if the decision is affirmed, it has to be based on the public online speech or third-party actions. Could you go over the direct conduct of the alleged direct conduct?
Thank you, Your Honor. I want to emphasize, first of all, that our client strongly denies that any of these acts ever took place, denied at the hearing.
So in terms of the judge's findings of the direct conduct.
Absolutely. So the judge's findings are quite difficult to understand, and they don't clearly identify the three acts, as this court has repeatedly encouraged motion judges to look at. But I think the judge does clearly identify one act in her findings. She says that there's a phone call where she credits the testimony of the plaintiff's employee, and after that, it becomes very hard to understand what the second two acts are.
So the first act, according to the judge, was an insult to the plaintiff's employee?
The first act, again, just taking at face value the judge's findings, was a phone call that included an insult that would not actually qualify as harassment, would be protected speech because it wasn't fighting words or true threats. And then one phrase, I believe it was, "I'll light you up," or something of that sort.
Same conversation?
At least on the basis of the judge's findings, that all occurred in one conversation, was one incident. Again, it's quite difficult going back into the record to reconstruct what the judge was relying on. The testimony from the plaintiff and her employee was frequently inconsistent. They disagreed about the content of the two phone calls that they testified to, but that's what the judge appeared to have credited in her findings.
Was there any discussion about what that term meant, light you up?
Your Honor, I believe, going back to the transcript and the testimony of the employee, he seemed to say that he interpreted that to mean with lots of false reviews online, so he didn't even interpret it as referring to physical violence, but otherwise that term remained totally unclarified in terms of its meaning.
You opened your argument by referring to two different possible bases upon which liability could rest, or not liability, but an order could enter. The first being direct speech by the defendant. The second being actions or speech by third parties. And I think what you said is if it was intended by the defendant, correct? And I don't want to misphrase what I understood you to be saying in the opening comments. Is that correct?
Absolutely, Your Honor. And again,
Okay.
I'm trying to divine the logic.
So I'm trying to now focus on the second half of that, which seems to me to turn on intent. So, because it looked to me from the transcript that there was plenty of actions or statements by third parties that would be true threats, right? Or even just physical threats. There were, that the judge could credit some of the testimony about things that physically happened, and it would be, that would not implicate speech. That would be just action, threatening actions. So the question then becomes, I understand it, that it is whether your client intended those by way of her protected speech. Is that analytically correct, at least from your view?
I would say that's part of our argument, Your Honor. I think one part is the question of intent. Did our client intend for those third parties to make these potentially threatening comments? The other is just the causal connection. Was there any causal connection between what our client actually did and what were those evidence of her doing at the hearing?
Okay, so
and
let
what these third
me
parties
then
did?
run this by you, because I do think that's the right analytical framework for the third parties. So let's just say that a person says, go deliver a flower to person A. And then it turns out that 6 people show up and threaten person A with a knife. And then the person then posts another statement and says, go deliver a flower, another flower to person A. And the same thing happens again. Can't the judge properly infer? Oh, and I left one thing out of my hypothetical, that the person knows the response that the first postings elicited. Okay? Why can't the judge infer that when the person knows the response that's elicited from her postings, that when she reposts the same thing, that she intends for that response to happen?
So if I understand the hypothetical, Your Honor, you're suggesting that what the culprit is doing is using some kind of code or giving some kind of...
Even if she doesn't understand the code, but she can see the causal link between what she's doing and what it is resulting in.
Your Honor, I would say those facts are extremely different from the facts that are presented here. When our client became aware that there were false reviews being posted, not threats, just false reviews, she immediately posted another video explicitly and sincerely instructing viewers to not do so. So I don't think there's any...
But then so the one thing that video definitely demonstrates to me is that she knew the reaction that, let's just assume even inadvertently, she precipitated by her first posting, right? So the news has gotten back to her that for whatever reason, when she's complaining about this business, it's provoking a sometimes violent reaction. Okay? Let's just say that could be fairly found from the evidence. And then there's the post where she says, don't do this. But she continues, that's not the only thing she says on that posting. She continues to repeat her negative view of the business. And then she has subsequent posts in which she goes on not only with the business, but with the information that it's, court records, things like that. So why couldn't the judge infer that those later statements were posted with the intent to elicit the same kind of reaction, which seems extreme? I mean, the numbers were huge, right, of the people who were looking at these videos.
The answer, Your Honor, is the First Amendment, that she can't be held responsible for commenting on her experiences with the store.
Unless, as I said, her intent in doing that, right? Because this is why I asked you originally if the test is, if the intent in exercising that speech is to cause the third parties to take some non-protected action, right? So you can't say, please deliver a rose to person A, if you know what's going to happen is people are going to show up to stab person A.
Your Honor, I would first, several responses to that. I think first, the intent requirement in the statute is incredibly strong. It's a double intent requirement. It requires malice, first of all, and then an intent to cause fear or intimidation or harm. That's a very strong standard to meet, and there would need to be, I think, more circumstantial evidence, more instances of, say, the multiple iterations of the saying, send him a flower, and then the violent response to establish that. And that kind of circumstantial evidence was just absent here. And I think, second of all, I don't think that the intent requirement exhausts the constitutional protections that are afforded to the defendant's speech. The defendant was caught up in this very troubling situation, and she had a constitutional right to discuss that online. And the reactions of others and what others do in response to that just doesn't take away or affect that basic right for her to comment on her experiences with this business and with the court system. That's a paradigmatic example of free expression and comment on an issue of public concern.
But doesn't context matter? I mean, you're asking us to look at each post and its content without looking at any of the history or the context in which they're taking place.
Your Honor, context absolutely does matter in interpreting the posts, and the context here is that the plaintiff and the defendant did not know each other. They encountered each other in person, actually just once, according to the record, at an entirely cordial evening. They spent, together at the same business. There was no evidence in the record that they ever saw each other again, had any violent interactions. This is not a case of a long romantic relationship or something where there's been physical violence or encounters. The context is really an extremely innocuous one of the defendant patronizing a business, having a mixed experience, leaving a factual review, as many of us probably have done ourselves, and getting hit with an enormous response, all kinds of different legal vectors converging on her in retaliation for her review, her commenting further on that online about her experience, exercising her First Amendment rights, and then getting penalized with a harassment prevention order for that.
Let me ask you this. The posts themselves, as you state, the posts themselves sort of factually go through the experience and what she wants to express to people. But an odd thing happens where the responses, the posts end up being strangely violent and hostile and, in a way that is not reflected in the posts themselves. So when you look at this, would it be fair for the judge to make an inference that something is going on behind the scenes, in the sense that this is what's being posted, but in fact, I think this may have been part of the testimony, in fact, what was going on is, in some other way, she's communicating with other people, asking them to put this kind of pressure on. Is that a fair inference from the record? So the quick analogy is, you see these kinds of cases, there's some animus between two people, and the person goes out and their tires are slashed. Nobody sees anything, nobody knows, but you can make that link based on the animus that's already here and then the timing. It sounds like the judge relied a lot on the timing of all of this happening, that she's thinking something else is going on. It's not just these posts. She's eliciting somehow people to come and do this. Can that fairly be done on this record?
Thank you, Your Honor. I see my time is almost up.
You absolutely can answer.
So, Your Honor, the answer is no, and I think there are two reasons for that. There are two reasons why that inference wouldn't be reasonable and permissible in this context. The first is the judge really relied on the idea that there had been this outpouring of tons of reactions, violent reactions. I think it is worth looking carefully at what the record actually does support in that. There was a small number of posts that were submitted as actual exhibits. It was the factual findings were very vague in terms of how many actually, what the content of these, were they just false reviews, were they angry reactions, were they threatening? That was, the the defendant only knew about false reviews, which are very different from violent threats. That's what she was aware of. The second point I want to make is, even crediting that there was this huge outpouring, there's just a big factual gap there in terms of inferring the existence of some kind of communication or arrangement of which there was completely no evidence. And There's
the evidence that the officer described the situation to her and asked her to stop and take her postings down. And so when she decides to disregard the officer's request, why can't certain inferences be made about her intent?
Your Honor, I do think it's quite troubling that she be expected to take down her posts, that's exactly.
Troubling or not, we're talking about she is informed by law enforcement of a situation that the officer at least believes her posts are creating, gives her information about that, and asks her to remove her posts. She then, thereafter, decides not only not to do that, but, which may be her right, but then to post new posts. With that information in mind, why can't the judge draw certain inferences from her intent, about her intent, from that decision of hers?
Your Honor, I would highlight that the officer did testify that he saw absolutely nothing threatening in the posts and materials that he was confronted with. And I believe in one of the videos, the defendant says something like, she represents that he said something like, this is going to be really complicated or bad if you don't take them down. That's exactly the scenario that is so concerning here, that using legal processes to chill and retaliate against speech and prevent the defendant from expressing her views about this issue of public concern. So I think to turn that in some way against her is exactly the issue here that we're raising with the First Amendment argument.
Do you have any more questions? Okay, thank you. We have
Thank you,
your
Your Honors.
argument. So because we've impounded the case, I'm going to, I mean, no disrespect, I'm just going to call you Ms. C.
Okay.
Oh. Yes.
Okay. Your Honors, thank you for taking the time to hear my side of things. Part of my attire, I'm in between houses right now, so I apologize. My attire doesn't match the severity and the seriousness I take this to portray. So the way that this case happened was there's one very important part that I want to be very clear. I totally believe in freedom of speech. I totally believe in, your opinion of your experience at my studio. I had no issue with her sharing her experience. However, she forgot to leave out one important factor, was that she was discriminatory towards my staff member, which is why we respectfully asked her not to return to the studio. The only person in the history of my business of 10 years that I've ever asked not to return. And it was because she did use this one specific word, which was very discriminatory and also accurate of my employee. So when, all of this began, it would be impossible for me to describe the amount of chill and the amount of fear that this instance put into my life. Never had any issue with her expressing her opinion on the studio. That was perfectly fine. But as you mentioned with that whole Rose example, the outpour of events that occurred after that was horrific. There were people from all over the world making threats on my life, my children's lives. My business, we had vandalism during that time, 2 instances of vandalism. So I, of course, called the authorities, and I explained, I said, I'm not positive that it's her that's doing this, but this vandalism, but it seems pretty connected. So the officer did, inference that, yes, it does seem very, there was it would be I'd get a message from, someone on Instagram that's never been to the studio, doesn't know me, and then immediately after something would happen, negative to the business, like vandalism or a new post. I went to bed on the night of this post, the original TikTok, and I had 50 positive reviews, all positive. The next morning I woke up and my daughter, 14 years old, came rushing in. She's like, Mommy, you have 3,000 negative reviews. It literally affected my entire family. I'm literally shaking right now, just reliving it.
Could I interrupt you just for 1 minute? And I apologize for the interruption, but did you bring to the judge's attention specific posts that you considered to be threatening? And if so, what did they say and how many of them were there?
So there were thousands and thousands of
But
posts.
specifically?
So there was one that said, she basically, don't mess with Asians, and I'm going to light you up. This is what happens when you F with Asians. And it just turned into like this like racial thing, which it was never about that at all.
This
So
was
that's in the
res-
record? That was submitted at trial?
Yes. And then I had two gentlemen, which is all video recorded, and I did show the judge, who actually came into my studio, like in like sunglasses and hats, and, were purposefully trying to disguise themselves. And I asked, they came charging towards me. And I'm like, can I help you with something? And I was alone. And they were like, I just want to buy a mug, a B mug. And this was the particular mug that was constantly being referenced in all of these posts. And then I just asked them to, take a couple steps back because they were making me feel uncomfortable. And, they started coming more towards me to the point of like touching me. So though that's not this particular person, it was derived from this negative review and this negative post.
Which you infer from the timing of when that happened.
Yeah.
Is that correct? Or is there more that I
There was
was overlooking?
countless.
No, with respect to that particular incident.
Exactly.
Okay.
And so what had happened was I never wanted to bring this to court. I really did
I
not.
want to go back to something, though, regarding timing. So,
Sure.
to me, it's helpful if we make clear which post you're referring to.
Okay,
So, there's the initial Google review.
right.
I take it you don't contend that anything that was in WJ's Google review was problematic from your point of view. It was just a negative business review.
Exactly,
Okay.
yes.
So, and you're not contending, I take it, that are you contending that that negative review, that WJ knew that negative review was going to precipitate, I guess there were a whole bunch of new negative reviews that just somehow got
Right.
spawned? Is there anything in the record to indicate that WJ knew that that initial review was going to trigger this reaction from people who'd never been to your studio or anything?
Not in my opinion, but I would say that the review wasn't accurate in terms
Okay,
of,
but, I mean,
but yes,
that's
no,
a different question.
Yeah, I disagree. I don't think she intended that.
Okay,
at that
so
point.
there's this, so at what point, so then there's subsequent postings. Are you able to create a chronology of any of the threatening acts, like the two people who came in? Because it was not clear to me from the transcript or the comments that you gave about Asian customers or whatever, that any statements that were before the judge or actions that were before the judge as having occurred that threatened you or made you feel threatened, are you able to fit them precisely into a chronology vis-à-vis the subsequent posts?
So after the first TikTok that was presented, that's when everything really started to explode. That was the night that literally 3,000 negative reviews came in. All people who had never been to the studio. And then there was even a Harvard professor who got on and responded and said, this is the kind of thing that can really hurt somebody. Not only the business, but the person. And, I'd respectfully ask that you take it down. He, responded to her, and she didn't do that. She actually continued to post. But it was during that first two TikTok posts that things really exploded, and that's when I had, people coming in, threatening my life, breaking my pottery outside that we, leave on the street to sell. There were just countless phone calls, fake appointments made, time-consuming events that were not business-related at all, not accurately, not accurate business dwellings, like appointments, reviews, just the fear. We had to shut down for the day after she posted the initial review because there was so many threats for my life. Just people stating that they were going to come
The initial review being the Google review.
No, initial review being the TikTok. And then the second one sparked even more, to the point where I did have Google involved. I got Google's legal team involved, and they did remove all the posts and blocked my account from being reviewed for a year. And I will tell you that about a month ago, when the HPO was lifted, I had the block for 1 year. The moment the block was lifted, we started getting negative reviews again immediately, as soon as the HPO was lifted. And I'm telling you, the same exact day. So I can show you the email if you'd like to see, where I contact Google again, and I said, would you mind actually throwing it back on there for, like, let's see if it, this will quit in 5 years. And so they put it back on. The Google team has been awesome. Travelocity is still being severely affected. Not Travelocity, pardon me, TripAdvisor and other platforms of people who have never been to my studio and are continuing to make these threats.
How long after the first Google review did the first TikTok posting, was the first TikTok posting?
I believe it was within a couple days. It was definitely very close. I don't know exactly, but it was definitely very close. And after I started getting the threats and I got the police involved, did not want to get the police involved, I did not want to go to court, none of it. The police officer respectfully asked that she take down the TikTok. I had no problem with her keeping the Google review up. No problem with it at all. In fact, I responded in what I always do when I get a negative or positive review. And then she didn't. She decided to keep it up. And that's when it just kept snowballing and escalating. The threats continued. And then finally, because of the fact that Google worked with me, these things happened. But I have subsequently had to take down my Facebook account for my business because of the way that Facebook they don't delete things. Like it's very difficult. So I've had to take action in taking down my Facebook for less visibility to my business. And, it's been quite a traumatic experience, to say the least. And I found it interesting that the moment that the HPO was lifted, they already started to come in, which was like to the exact date.
You understand that the statute requires 3 acts?
Yes.
Okay. Can you tell us just 1, 2, 3, what the 3 acts are in your view?
Right. So there was the initial interaction, which was positive. That I'm going to tell you how.
I'm going to ask you. It helps me if you can just answer succinctly.
Yep.
1, 2, 3. What was the first in your view?
Yeah. So the first one was when she called my employee.
The telephone call.
Correct.
Okay. The second one?
Second one was when she came and she picked up her pottery. And she used that exact same word. I think it was her brother who ended up walking towards the door.
She did not pick up the pottery.
So when her brother came, he made a comment on her behalf and said that, when did you...
Are you able to tell me where in the trial transcript it says that the brother said anything? Because I didn't see that.
It was definitely expressed
Okay,
to the
so your
judge.
second act is when the brother came to pick up the pottery and used the same word.
Correct.
Okay. And the third?
And the third was what the judge viewed as the TikTok videos where she outwardly
Right,
gives
but we
me
can't
public
use them
info.
as an aggregate, so I'm going to ask you to say what's the third.
The third are the TikTok videos.
All of them
continued.
together?
Correct.
Okay, now if I had to ask you to identify one?
I would say there was 4 of them, and I would say between 2 and 3 were the most, I can't decide between the second and the third.
What was it about the TikTok video that you're
So
saying?
she gave personal information about me, multiple examples of personal information, of harassment, intentional, trying to disparage me to the world, knowing that, millions of people were viewing this.
But you understand, we have the video, so we can look at them.
Yeah,
But
so-
what I'm uncertain about is what What is it within those videos that you're pointing to specifically?
Bringing up the fact that I was going through a divorce at the time, bringing up the fact that I was in a legal situation that stemmed from my divorce with a judgment on my home. Just irrelevant information that have nothing to do with her experience. I'm more than happy if it had everything to do with the experience, but it was the fact that, she was attacking me personally, bringing up, information about me that had no relevance whatsoever to her experience at the studio. And being asked repeatedly by law enforcement, which are the higher, powers that be, to just simply take it down and, not continue this absolute tirade on my life, which still continues today. And I respectfully ask that you don't allow this appeal to go through, because I'm afraid that she is not going to relent, and I'm afraid of what.
You heard, heard Attorney Miller say that the order has expired.
Yes,
There's been no subsequent order, I take it.
not yet, no. I did file a defamation of character lawsuit against her, and I did drop that respectfully because I hadn't had any, continued effort towards her, from her, and so I respectfully dropped that lawsuit. So to be here today is a bit upsetting for me because I've had put countless hours and energy and effort into this harassment.
Okay, let me see if there are any further questions.
Okay.
Just when the date came for this order to expire, did the parties appear on the expiration date? Did you appear?
No. And if you don't mind, if I could add one more thing. There were 2 dates, which I'm sure you already know, in court. There was the first date, and then she tabled it so we could all just,
We know that.
and that didn't happen.
Yep, so your time is expired.
you.
I'm going to see if there are any further questions for you. No, okay, seeing none.
Thank you.
Thank you very much. We've been helped by both sides' argument in that case, and the case is submitted. All right, the next case on our list is 2022 P0915, Paul Jones versus Montachusets Regional Transit Authority. And Mr. Jones, take your time.
May it please the court, my name is Paul Jones.
You can set yourself up. Take your time to set yourself up.
Okay.
We're ready whenever you are, when you want to start your argument. And you'll have 15 minutes to argue.
Okay, I see the clock here. May it please the court, my name is Paul Jones. I'm the appellate in this case, pro se. This case, I'm asking this court to remand this case to the lower court with instructions that the Title VII cannot determine if an individual is an employee under Massachusetts Wage Act. This case is about the Massachusetts Wage Act. I worked for the appellees for 3 years, a little over 3 years. For 3 years, I never took a day off because of their rules. And basically what happened was I had a federal Title VII case for discrimination, retaliation, and hostile work environment. It was stalled during the pandemic. So I filed the case here. That hadn't been adjudicated yet. It was in the discovery phase, practically. And when I filed this and came to court, the appellees claimed that the case had already been adjudicated and I shouldn't be here, and that wasn't true. You'll see in the record that I got the transcripts and everything from all 3 hearings where the appellees said that the case was adjudicated, so they claim preclusion. But in order to do that, it has to be a prior case that has been adjudicated. It wasn't done so. It wasn't. And the Wage Act is clear. There's no shifting the burden on the plaintiff when a plaintiff files a Wage Act case. Usually it goes forward, and the appellees or the defendants, they do the ABC test.
But
And if
just to step back, and I'm sorry to interrupt you, but Mr. Jones, you as the person contending that you're the employee under the Wage Act have a burden initially to prove that you provided services to the ostensible employer, to MART,
Yes.
right?
Yes.
And in this instance, from what I see in the record, your complaint alleges that you created a corporation in order for the corporation to enter into a contract with MART,
Yes.
and that the MART required that you be an independent contractor in that way.
Correct. Under the Wage Act, one can't hide behind a contract. The Wage Act clearly, specifically, it's a strict liability, and it says anyone performing a contract, anyone performing a service is deemed an employee.
For the employer, right?
Yes.
But the argument that I think that MART is making is that, in part, that you are not an employee of MART, you are an employee of the corporation that was formed in order to have a contract with MART.
Yes, that's one of the arguments that they're making, but there can be a joint employment also, because whoever in previous, I've quoted a lot of case laws and for the Independent Wage Act, and all of them pertains to the plaintiff having a contract under a corporation. So they mandate that you have a corporation and that you work for the corporation. I'm transporting their clients throughout Massachusetts. I'm providing them a service. The Wage Act says once you provide them a service, and I'm also providing the corporation a service too. I'm providing both. So once I provide them a service, they are deemed my employer.
So then, if I can jump ahead, and maybe this is jumping ahead too many steps, and if so, I apologize for cutting off
Okay.
the argument you were going to make. If we assume that you made your preliminary showing that you provided services to MART, then the burden shifts to MART to rebut that with the ABC test. Is that what your argument is? Am I following that?
Well, the
So
first
far?
argument is I am an employee because I provided a service to them. I personally transported their clients to doctor's appointments. I'm a transportation company, they're a transportation company. I provide, that's my first argument. And what was the question?
So the way I was understanding the test was that the initial burden was on you to prove that you provided services to MART. Then MART had the obligation, and that's where the ABC test came in, to prove 3 things, all of them. One, all of those 3 things.
Yes.
And so my looking at what was decided in the federal court, that determination that you were an employee was based on essentially common law principles about control. Is that right?
It was based on Title VII, which is a federal statute. Even the late Judge Grants has said, it's in my my reply brief, he has said, you can be deemed an independent contractor in one case and an employee in the other. This is well-settled law, and the SJC has said that, and it's in my, I believe that's the first paragraph.
So assume that I'm with you on that, and that my reading, at least personally, my reading of Judge Hillman's decision was that he determined that considering issues relating to MART's ability to control your work, that you were not an employee of MART. That was in the federal court action.
Under the Title VII, yes,
Right.
correct.
Then looking at the ABC test, if that test requires part, and understanding that it may be a more protective test, that under Part A deals with the issues of control in a way that arguably is parallel to the way that the federal court dealt with the Title VII issue. If A were off the table, then what is your argument about MART's ability to prove B and C of that test? In other words, I'm asking,
I understand.
would the motion to dismiss have been properly granted if only A were
Okay.
decided?
So they still can't clear the hurdles of B and C. B says the service is performed outside of the appellee's course of business. Their course of business is transportation. They're a transportation company. I'm doing transportation for them. So they have to consider me an employee. They cannot overcome the hurdle. Even if we assume that the Title VII control issue, one, give it to them. They can't overcome B. C, an individual engages in his own independent established business. Under the contract that I was working for with Mott, I was not allowed to transport any other individuals from another contract while I had their people in the car.
I didn't see that in the contract. Can you please point me to the paragraph?
Sure. I copied and pasted that whole,
I'd like to see it in the
Yes.
contract.
let me see, let me go to the, well, actually, yes, I'm going to find it, but anyway,
So I'm on the contract, which begins on Record Appendix 35.
35, gotcha. Oops.
I think that's the contract. And I didn't see a provision in there
35.
that says that
I can't
you
transport.
can't transport, you can only provide transportation services exclusively to MART.
No, it didn't say that. It said
Okay,
I
so
can't mix the clients.
Oh, that's a different story. It looks like on the same trip. Please show me the paragraph so I can know exactly what you're relying on.
Okay, you want me to show you the
I
paragraph?
want to
that-
show you, I want you to tell me the paragraph that you're relying on for the statement that it precludes you from providing services to anyone else.
No, it's not there. What it precluded me from doing was mixing clients. And if I have a schedule with them all day, I can't work for someone else.
Okay, what I understand that, show me the paragraph and then we can talk about it.
Okay. This is going to take up a lot of my time. I don't know where it's. Is it possible I can resend it to you after? Because I only have 5 minutes left. Can I send it to you after?
Well, what I understood that paragraph to say is that you can't be transporting a MART customer and a non-MART customer at the same time.
Correct.
Okay, but it doesn't say you can't transport non-MART customers at other times.
No, it doesn't. You're absolutely right.
So it doesn't preclude you from transporting other customers
No, it precluded me from transporting, mixing.
at the same time.
At the same time.
Okay.
You're correct.
All right.
You're correct.
You had just mentioned that, but the problem with that is that all of your time is spent taking their clients.
Yes.
So you effectively have no ability to really have an independent enterprise.
Exactly. I can't, because if I'm working for them, they will give me a call at 9 to 10, and then won't give me another call to 12 to 3, and then from 3 to 5. And it's no way that I can work for someone else during that time. Nobody's going to hire me for 1 hour a day.
You had the right under the contract, if I understand correctly, but correct me if I'm wrong, to turn down MART assignments?
Yes, but I would get penalized. You would get penalized if you turned down several. I've gotten penalized over $10,000 in the last 3 years for turning down trips, being late, whether it's not my fault or what, on the highway or whatever, you know. And another thing they was doing in the contract that was, you know, far as control under the Wage Act. Every time I got paid every 2 weeks, they wanted a list of everything I did with the money, of who I pay, gas, supplies, utilities at my office, tires, anything that had to do with the business, they wanted an accounting of that. Their rebuttal to that was, well, we said that in a contract, but we never asked him for it. Yes, you did. You know, they control me. I had badges. I had to go to their facility and train. I couldn't do a call until I trained at their transportation facility. So they can't get over B because they're in the same business. And even Hillman, even Hillman's decision in the federal court, he said that Mark is in the same business as Mr. Jones, a transportation company. And under the Wage Act, you have to overcome all three. They can't do it. They can't do it.
Can you tell me what the status is of the individual defendants you originally named? I take it you're not...
Say that again?
There were some individuals you named as defendants?
Yes.
But they're not part of this appeal, is that correct?
Yes.
You haven't made any argument with respect to them?
Well, no, I haven't. But
Okay.
I made an argument in my in the court, in the transcripts and everything, regarding that they were managers and supervisors that controlled the day-to-day operations, and under the Wage Act, they're eligible to be sued individually. And one other thing before, because I only got a little bit of time, the appellee's attorneys in a SJC case that just came out in April, Roters versus City of Methuen. The SJC just ruled on the Wage Act. It says what it means and it means what it says. In that case, the attorney interjected interest into the statute. And interest is not in the statute. It's not the Wage Act interest. And even in my case, she's interjecting Title VII. Title VII is a federal statute. It's separate. Even the late Judge Grant says you can be found an independent contractor on one case and an employee on the other. The Employee Wage Act is strict liability. It means what it says and it says what it means. You can't interject words. It's not the Wage Act / Title VII. It's apples and oranges. The wage, if they want it like that, I think the legislation would have made it like that. The Wage Act is the Wage Act. The Title VII is the Title VII Act. Any other questions?
No, and I think we understand your argument. So, and we have your brief. You have a few
Yeah, and the
seconds left.
The last thing I want to say, they have to overcome the ABC test. And I would like you guys to remand it, and like I said, to let him know that you can't mix the Title VII decision with a Wage Act decision. Thank you.
Thank you. Is it Attorney Decker?
Sorry.
Is it Attorney Ecker?
It is, yes, Attorney Ecker for defendants. May it please the court, I'm Deborah Ecker for the defendants. Mart, is my understanding, is the only defendant here today.
But why do you say that?
Because I believe, and I'd have to check because I hadn't thought about that till you raised the question, but the Wage Act can only be brought against the employer.
I don't think that's correct. And I didn't go to research this, but I have had cases where individuals were named as defendants and I believe had liability individually under the Wage Act. We'll double check that, but I'm puzzled because it looks like all defendants were dismissed below. But if we were to, well, maybe we'll just get to that bridge however we get there. But there was, it doesn't, who did you file an appearance on behalf of?
All of the defendants.
All of the defendants.
All of the
Okay, so
defendants.
let's assume that they're before us.
Okay. So what we're talking about here is the violation of the Wage Act. And so what my brother has argued is he's an employee versus an independent contractor. By law, he is neither. We are a transit authority established by statute. By statute, we cannot employ transportation.
I didn't see that in the statute, so I'm going to have to ask you to give me the specific language. I understand it's in Chapter 161B.
Section 25, which specifically says,
Okay, so let me just get there, please. You're probably way ahead of me. 161B. Go ahead. Section 25.
yes.
So, so you are, it's amazing how far off base I can be. Don't stop, just.
I can tell you what it says. It
Yep.
says, "Nothing in this chapter shall be deemed to authorize or permit any authority established by this chapter to directly operate any mass transportation service." So the transit authorities that we represent, this is a little bit different program. This is transporting Commonwealth and Massachusetts clients, but retain companies by contract who then provide the transportation, provide the employees, whether they be under those contracts that they have, the transportation providers have, whether they be employees or independent contractors.
It doesn't preclude the MART from having employees.
MART has employees, the
Right,
named
and it doesn't
defendants.
preclude, I didn't see that it precluded MART from employing people as drivers.
I can tell you that that's how this has always been interpreted
By
by
whom?
by the transit authorities, and I believe I don't have a case for you.
I didn't see any citations in your brief. I just saw this language, and it wasn't clear to me that I did see the language that you read, but I didn't see that the statute precluded MART from employing people as drivers.
So the language that we're relying on, they cannot directly operate any mass transportation services. We cannot provide the transportation.
But these are not really mass transportation services, right? These are individual clients being transported from one place to another?
So what MART is basically the broker between the Commonwealth, under this program. The Commonwealth of Massachusetts clients need transportation. And so MART is basically brokering, right? Connecting them with transportation providers.
Right, so that sounds different than operating a mass transit authority or system. Doesn't sound like that's what you're doing.
Not under this program, no.
Right, so I don't see then how Section 25 would preclude finding someone to be an employee of MART.
It would preclude that from finding that a driver is an employee of MART. MART has employees, but not drivers.
It appeared from the reply brief and the materials attached to the reply brief that MART does have employees who are drivers.
They do not. All
Okay.
of the transportation,
So in any event, I don't think, at least at this stage, any of this matters, because it's a motion to dismiss. We're confined to the allegations of the complaint, and I don't even think we reach any of that yet. So I'm going to assume that, just for my purposes, okay, I'm going to assume for my purposes that I don't think, well, I'm going to ask a predicate question. Do you believe that the judge below decided the case on res judicata grounds?
I do.
Okay, so I'm going to ask you just to assume that that was incorrect. Just assume. I'm not asking you to argue that, I'm just going to ask you to assume that that was incorrect. I then take it that you are arguing that nonetheless, the complaint was properly dismissed because it fails to state a Wage Act claim.
Correct.
I'm wondering how, on the basis of the complaint alone, you get there.
Plaintiff has admitted that he works for CCRD. He is the director of CCRD, which is the company that has the contract with MART. The contract, and plaintiff admit, he submits rates. Whatever the rate may be, MART doesn't control that rate. Plaintiff can accept or decline assignments. Plaintiff can work for other companies. He cannot mix, in answer to your question, he can't mix clients, meaning he can't transport one of the MART, assignments with, let's say, I don't know who else, would call, almost like an Uber, right? Would call the Uber. You can't mix, but you can certainly work for another company. They get to set the time that they work. Plaintiff had wanted to work, and I'm forgetting the exact hours, 9 to 3 or thereabouts. MART transports a lot early in the morning. That's up to plaintiff. So it's our contention, even based on the allegations contained in the complaint, you're not an employee and you're not an independent contractor. Your employer is CCRD, the company that had the contract with MART.
But why is it, if we take the allegations of the complaint in the light most favorable to the plaintiff, as we must, that it doesn't allege that the purpose of this contract was to make someone who's actually an employee look like an independent contractor?
Putting the statute aside, they're not in the same business because we're brokering rides. We're not transporting, but that, I guess, would go to the allegations and complaint. We'll take them.
Take them, you have to take them as true. We're not going to upend the law of motions to dismiss for this case.
Right, and we're, aside from the res judicata effect.
Right,
the federal
I'm
court,
setting that to the
We're taking that
side.
out of the mix.
Yep.
Again, there's no the control issue, even based on the allegations contained in the complaint. The simple fact we have this contract, this isn't like an Uber situation where they contract directly with the individual, and I'm using them as an example, but with the individual drivers. This is CCRD, whom plaintiff is an employee, and the director has other employees, or at
Do
least
we know all of this from the complaint itself?
I believe so, Your Honor. If not, it's in the federal court complaint.
But it's got to be in this complaint, right?
Well, not necessarily. I think Your Honors, on a motion to dismiss, can take other pleadings into account.
No, not for sufficiency of not for the sufficiency of the pleadings.
Okay.
It seems to me that all the issues you're bringing up, trying to sort of bring out factors establishing or not establishing control, or this is all ripe for further discovery and evidentiary hearings.
But we had that, Your Honor, in federal court. We had a federal court complaint that was filed, and the sole discovery was on whether he was an employee. That was it.
Well, but
Pursuant to the Wage Act.
right.
Not pursuant to the Wage Act, but there were findings that were made.
Are you saying that they're exactly the same, the determination of an employee under the federal case and the Wage Act?
They're not exactly the same, but the factual findings made in the federal court go to all of the 3 standards that are here in the state court. It goes to control, it goes to the business, it goes to...
See, but if the definition of employee is different in the other action, then the plaintiffs or the parties are motivated differently as to what factors they're going to establish. If it's a different definition under a different action, then you're going to be motivated to present other evidence.
Respectfully, Your Honors, this was broadly argued in the federal court, and I hear what you're saying. There were depositions that were taken, and again, the evidence really is the same that was put in. We have a contract, the assignments, that you can take, you cannot, you can't you can do your schedule. Same issues, same that would arise here, same facts that would arise here. And again, I refer back, one, to the statute as well. The contract is with CCRD. I hear what you're saying, but the contract is with CCRD, and maybe I'm confusing complaints, but my brother had other employees. One of the complaints was that he had to fire his employees because there wasn't enough business from Mart.
That I don't believe was in this complaint.
Okay.
I mean, I don't know. You probably know better than I did, but I
I
have read the complaint. I don't remember seeing that.
So the state court judgment indicated that the findings of the federal judge were being adopted.
Correct.
And you think that's appropriate in the state court action on a motion to dismiss?
I do, Your Honor. I do. I don't think you should be able to file, two when the decision, and in fact, the lower court initially stayed this case while discovery was going on in the other case, so that they had the benefit of having that decision so that there wouldn't be discovery as well. We had filed a motion, so when we originally filed here. So
all those factual findings could be, what I'm trying to get at is all those factual findings could be adopted and supported by what's in the complaint, or is the judge really looking at something beyond the complaint at that point?
The judge in the Superior Court,
Yes.
you mean? Okay. So the judge in the Superior Court read what was a pretty detailed federal decision, adopted, as I understand it, the facts.
Right, to undermine the allegations of the complaint.
Correct.
I've never seen that done on a motion to dismiss. Do you have a case that says that's permissible?
I don't. I actually, that's the sole reason this case, there was stayed, so that we can get this federal court complaint.
I mean, right, I'm not saying that was correct either.
I hear you, but
Okay,
if
I
not,
mean, the problem is, it may be that people jumped the gun. This all may be ripe, as Justice Singh suggested, on a dispositive motion of a different sort, like a motion for summary judgment, or where the question of
well, then, Your
race
Honor-
judicata.
I'm sorry.
But, it's difficult when you have to accept the pleadings, the complaint.
Then I would say, Your Honor, because it was stayed, our original motion to dismiss then here should be heard on the statute, which I understand you don't see the same reading in, but 161B, Section 25, Mart does not hire employee drivers.
Right, well, we could affirm on any ground. So, and you've raised that as an alternate ground for affirming the dismissal. And that's why I asked you about it up front.
Yeah, no, I appreciate that, Your Honor. But yes, that, if we go back, that's what we would do. We would file, again, a motion, I guess it would be, I don't know what it would be called, motion to dismiss or motion for judgment on the pleadings based on the statute that we don't, and we can't by law, hire.
I'm actually going to ask, do you have any more questions? Do you have any more questions? Okay, I'm going to ask each side to file a supplemental memorandum of no more than 5 pages each. Each one of you to file that within 7 days of today, so next Thursday, if I have my days of the week correct, on Chapter 161B, Section 25. It's limited to that, so that you both understand we're not looking for just some free roaming briefing. Limited to that, and in particular, it would be very helpful if there are any cases or other authority construing that section. So that I did not see in the parties' briefs. You argued about what it means and what Mart does, but I understand from the argument today that people say that there are either agency or other decisions interpreting that section, and I would like to know what those are. So or I should say, we would like to know what they are. And so, do you understand, Mr. Jones, what I'm asking you for? The most helpful thing here is that it be content-heavy. This is a short submission, and not so much argument, right? So because we go and look at those authorities that you give us, you can, of course, include argument, but please don't make it just argument. We're looking for authorities,
Understood.
okay? Sure. Sure, of course you can reference the, but you see, what I'm asking you here is for a supplemental memorandum of law, that where I'm looking for decisions. And if you think that in explaining those decisions, you would like to tie it to the facts of this case, of course you may. But what we're really looking for is some help with understanding Section 25 of Chapter 161B. Does that? Right, if there is any. I don't know.
Understood, Your Honor.
Okay?
Understood.
So thank you very much. It's a very interesting case, and we've been helped by both sides' argument. So with that, the case is submitted.
Thank you, Your Honor.
And before we go on our adjourn for the day, this is at least this panel's last sitting in the John Adams Courthouse this term, and I want to take the opportunity to sincerely thank our court personnel for helping us throughout the term and today. It's been, I think, a real, it's been a tough year in a lot of ways, and we really appreciate the help. Thank you.